Bar Rules Series. Will.
Will formation. Creation of valid will. A valid will requires the testator to have 1. Capacity, 2. Testamentary intent, and 3. Meet all will formalities. Validity. Attested will. A will must be signed, in writing, and witnessed by 2 people. The witnesses must know they are witnessing a will. Together see the testator sign or affirm his signature, and sign during the testator's lifetime. Interested witness. A witness of attested will who is a beneficiary under the will is an interested witness. The validity of the will remains, but a rebuttable presumption is created that the interested witness exerted undue influence over the testator. The presumption can be rebutted by the presence of 2 other uninterested witnesses, or by clear and convincing evidence that the testator intended the gift. Substantial compliance rule, harmless error doctrine. If a will is not executed in compliance with the witnessing requirements, it may nevertheless be treated as valid. If the proponent of the will establishes by clear and convincing evidence that at the time the testator signed the document, he intended it to constitute his will. Conscious presence doctrine. A witness is in the conscious presence of the testator if the testator is generally aware of the witness's presence and of what the witness is doing, even if the testator does not actually see the witness sign. Holographic will, codicil. A holographic will, codicil is 1. That is signed and 2. Contains material provisions. 3. In the testator's handwriting. It need not be dated or witnessed. California recognizes a holographic will as valid. Choice of law. A will is valid if it is properly executed in the state where 1. The testator was domiciled at the time of execution, or 2. The testator was domiciled at the time of death, or 3. The will was executed. Capacity. The testator must 1. Be at least 18 years old and 2. Have the capacity to understand that he is making a testamentary act, the extent of his property, and relations with family members. Insane delusion. An insane delusion is a false belief not based in reality, maintained despite clear evidence to the contrary, and which materially affects the will's disposition. Undue influence. Undue influence is excessive persuasion that overcomes the testator's free will, leading to an unnatural disposition. Factors to consider include 1. The testator's susceptibility to influence. 2. The opportunity for influence. 3. A special relationship. And 4. Effort in procuring the will. Either the entire will or a specific gift may be invalidated. Presumption of undue influence. California's statutory presumption. A presumption of undue influence arises if any provision in a will that makes a gift to 1. The person who drafted the will, or 2. The person who transcribed or caused the will to be transcribed while in a fiduciary relationship with the testator at the time of transcription, or 3. A care custodian who provided services during or within 90 days before the gift. The presumption does not apply if 1. The recipient is a blood relative or cohabitant of the testator. 2. The gift is $5,000 or less. 3. An independent attorney reviewed the will and determined there was no undue influence. Fraud. Fraud in the execution occurs when 1. A testator does not know he is signing a will, is not told of its contents, or 2. The will is forged by another. This renders the entire will invalid. Fraud in the inducement occurs when a wrongdoer influences the testator through misrepresentation, causing the testator to include certain provisions in the will. Those provisions are invalid. fraud-preventing will execution or revocation occurs when fraud prevents a testator from executing or revoking a will. If the will was already executed, the court will 1. Probate it, but 2. The wrongdoer must transfer the property to the intended beneficiary under a constructive trust. Mistake. An unambiguous will may be reformed to conform to the testator's intent if clear and convincing evidence establishes that the will contains a mistake in the testator's expression of intent at the time the will was drafted, and also establishes the testator's actual specific intent at the time the will was drafted. Extrinsic evidence, including statements by the testator, is admissible to establish both the mistake and the testator's actual intent. Constructive trust. Equitable remedy when the defendant wrongfully acquired the property. Components of a will. Plain meaning doctrine. Word in a will must be interpreted in their plain meaning, and extrinsic evidence is inadmissible. However, extrinsic evidence is admissible if a patent or latent ambiguity can be shown. Integration. Papers will be integrated into the will. 1. If they were present at the time of the will and 2. There is evidence that the testator intended them to be part of the will, such as attachment, stapling, or numbering. Extrinsic evidence is admissible to show the testator's intent and to establish whether the documents were part of the will. Incorporation by reference. A writing outside the will may be incorporated if 1. It was present at the time of the will, 2. The testator intended it to be part of the will, and 3. The will sufficiently identifies the writing. Pour-over will. Incorporation of trust. A pour-over will is provision that transfers a testator's probate assets into a previously established trust upon death. It is valid if 1. The trust is identified in the will, 2. The terms of the trust are set forth in a separate instrument, not in the will, 3. The trust was executed concurrently with or before the will. Acts of independent legal significance. A will may dispose of property by reference to acts that are independent of their effect on the will. Changing a will. Codicil. A codicil is a supplement to a will that alters, augments, or modifies the provisions. It is subject to the same formality requirements as a will. When a codicil is validly executed, it republishes the original will as of the date of the codicil, which may cure certain defects. Revocation. A will may be revoked, in part or in whole, by a physical act or through a subsequent will. A physical act involves an act with intent to revoke. A subsequent will may expressly revoke, or impliedly revoke through inconsistencies. Physical act. A testator can revoke a will or codicil by destroying it, including one of its duplicates, with the intent to revoke it. If a testator tears up only part of the will, but the intent was to revoke the entire will, then the entire will is revoked. The court may consider the extrinsic evidence to prove the intent. A will can be revoked by another person only if 1. Done on behalf of the testators, 2. At their request, and 3. In their presence. Operation of law. Revocation by operation of law means the law automatically changes a will by adding or removing beneficiaries or assets. Under CA law, divorce or dissolution of a domestic partnership automatically revokes all will provisions in favor of the former spouse or domestic partner, unless it can be shown that the testator intended for the will to survive. Separation does not revoke the will provisions. Omitted spouse. A spouse is considered pretermitted if the spouse married the testator after the will was signed, and was subsequently never included. There is a presumption that the spouse was erroneously omitted, and they receive their intestate share unless 1. The spouse was intentionally omitted. 2. The spouse was otherwise provided for outside the will. Or 3. The spouse waived their right in a valid agreement. Omitted child. A child is considered pretermitted if they were born or adopted after the will was signed and subsequently never included. There is a presumption that the child was erroneously omitted, and they receive their intestate share unless 1. The child was intentionally omitted. 2. The child was otherwise provided for outside the will. Or 3. The testator had other children and left substantially all of the estate to the omitted child's other parent. Dependent relative revocation. Under the doctrine of dependent relative revocation, DRR, a court may revive a previously revoked will if the revocation was based on a mistaken belief of law or fact, such as the assumption that a new will would be valid. To apply DRR, the proponent must show that 1. The testator would not have revoked the original will but for the mistaken belief, and 2. That the testator would have preferred revival of the revoked will over dying intestate. Revival. The revival of a revoked will must be made by an express declaration to revive in a subsequent instrument. If the revocation occurs through a subsequent will, 1. Revoking the subsequent will does not revive the original will unless there is evidence of 2. Intent to revive. Distribution of gifts. Classification. Specific devise is a gift of a uniquely identifiable item. General devise is a gift from general estate assets. Demonstrative devise is a monetary gift that is general in nature, but the source of payment is specified. Residuary devise is the gift of what remains after other gifts. Distribution of CP and SP. A spouse can only devise, will away, their 1/2 share of the CP. If a testator attempts to devise more than their 1/2 CP share to a third party, the surviving spouse may choose, either 1. Accept the gift under the will, or 2. Take their statutory share under state law and disregard the will. Ademption. When a specific gift is no longer present in the estate, the gift fails, unless there is evidence that the gift was demonstrative, in which case the gift becomes general and does not ademe. Additionally, in California, ademption may be avoided if the gift merely changed form and there is evidence that the testator intended the beneficiary to receive the substitute or equivalent value. Satisfaction of legacy. When a beneficiary receives a gift during the testator's lifetime, the gift is treated as satisfaction of a legacy only if the testator expressed an intent that the gift was in satisfaction of the will. However, if the gift was made from parent to child, it is presumed to be satisfaction of the will. Abatement. When the estate does not have enough assets to satisfy all gifts, the gifts will abate in the following order: residuary, then general, then specific. Relatives may take priority over non-relatives in equitable circumstances. Exoneration. Under common law, a devise of property in a will is presumed to pass free of any encumbrances, to be paid from the general estate. However, under modern law, and in California, the devizee takes the property subject to the debt unless the will expressly directs otherwise. Lapse. If the beneficiary predeceases the testator, the gift fails and falls into the residuary. But under California's anti-lapse rule, if the beneficiary was a blood relative of the testator and left issue, the gift passes to the issue, unless there is contrary intent in the will. If beneficiary is alive, simultaneous death. If the beneficiary and the testator die simultaneously, the beneficiary is deemed to have predeceased the testator, and the gift lapses. Slayer statute. A beneficiary who is convicted of the intentional felonious killing of the testator is deemed to have predeceased the testator, and the gift lapses. The anti-lapse rule does not apply. Intestate succession. When a decedent dies without a valid will, the estate is distributed by the rules of intestate succession. Spouse's share. The surviving spouse takes all of the CP. If the decedent had no issue or primary relatives, the spouse takes all of the SP. If there was one child or parent, the spouse takes half of the SP. If there were 2 or more children, the spouse takes 1/3 of the SP. The remainder is divided by the children or parents. Division of remainder. Per capita, each generation gets an equal share. If there are deceased takers, their combined shares are redistributed equally among their issue. All grandchildren get the same. Per capita with representation. Modern per stirpes. California follows this division. The shares are divided equally, 1, at the first generation where at least one member is living. 2, each living member shares equally. 3, if the taker is deceased, their issue divides the share of the parent. 120-hour rule. An heir must survive the decedent by at least 120 hours or be deemed to have predeceased the decedent. Advancement. Under the doctrine of advancement, property given to an heir during decedent's lifetime is treated as part of heir's share.